All right, we're just getting ready to start our landlord tenant docket. We've got the live stream up. We'll turn the recording on in a moment. I have only one defendant here. Good afternoon, John.
Oh, Judge.
We've got memory lane at 115, 120, and 125. We set these on a short window. So far, I don't have Bettina and I don't have any defendants other than one. Well, we'll see how we do. Things get a little more. There's Chris. Here's Bettina. Good afternoon, Ms. Corpening. Good afternoon, Bettina.
Good afternoon, Your Honor.
Oh, Chris.
We'll
Morning,
let the
John.
clock tick a little bit. It's 1:12. The power went out last week, as I mentioned, a week ago Thursday. They just got around to resetting the clock. Every time I looked up, it said it was like 3 a.m. or something, but we're back. I think the clock on the wall matches the clock on the calendar. While we're waiting, I guess I can inquire as to Mr. Angus. Did he pay the rent? He had a plan to get everything paid up.
Chris would have to answer that.
Am I on mute?
Your Honor, the day he went to court, the very first day he went to court, he put $1,000 in the box, and that's all he's paid since then.
All right, well, we'll wait till he logs in here. He had a plan with a stimulus check and his tax refund, and we referred him to Keystone.
Yes.
$113. Miss Emery, have you been busy? Oh, she's on the phone. She's busy helping people pay their rent.
Yes, Your Honor.
Is she run out of money yet?
Oh no, we're still giving it away.
Well, it's a win-win. If the landlord gets paid and the tenant gets to stay and things are turning around, there's certainly lots of employment out there.
Definitely.
All right, let's call this case. It's entitled Memory Lane Mobile Home Park versus Tristan Angus. The file number is 21428LT. Present with us are John Bush, who is the attorney for Memory Lane Mobile Home Park. Their manager, Chris Corpening, is present, and Bettina Emery from Keystone Place is here, our housing advocate. We had a hearing, I'll go ahead and bring Mr. Gilmore in, he's coming up, back on April 30th. And the defendant represented at that time that he was going to pay everything and get caught up. We recommended him to Keystone and scheduled the matter for today, some 37 days later. Bettina, have you had any contact with this person?
No, Your Honor, I have not.
Well, that's a disappointment. Keystone. And according to Ms. Corpening, defendant had paid $1,000 the day of the last hearing and paid nothing since. What's the current arrearage, John?
Is it, well, another rent may have come due, Christine. You want to tell the current rent?
We did through May, $4,559, and June has come up.
So I believe we probably have another $855 to add to that.
All right, 4,559 plus 855 lot and trailer rent equals 5,414.05. Ms. Corpening, is that what you have?
Yes, it is, Your Honor.
All right, well, I'm not sure why, is he still there?
Yes, he is.
Well, he's not here now. I'm gonna do a $5,414 through June. And we've got $55 filing fee, $46.16 service fee, and a $75 statutory attorney fee, which is $176.16, plus 5,414. 0.05 equals 5,590.21. Now here's somebody who's logging in as Heather's phone. Let's see who this is. It's not Mr. Angus. All right, today is June 7th. The date for the writ is June 17th. It's also the date for the appeal. All right, we'll set that aside for a moment. In case he logs in while we're working on some of our others. Donald Rhodes and Nicole Roy are next. Heather Schrock and Gary Gilmore. They're set for 1:30, but I guess we can go ahead and do that. We've got both parties. Ms. Schrock, can you hear me?
Yes.
Mr. Gilmore, can you hear me? Mr. Gilmore?
Yeah, I can hear you.
Can you be? All right, I'm going to ask you to put your cigarette out. We're in a hearing and you can see the smoke wafting through the feed. This is file 21431LT. It's entitled Memory Lane Mobile Home Park versus Heather Schrock and Gary Gilmore and all occupants. We made a finding that there was some rent due. Bettina was present. We continued the matter until today. Rent at that time was quite substantial. Through May, it was $6,460. Ms. Corpening, has anything been paid?
No, Your Honor, has not.
Bettina, what can you tell us about this one?
The household did not qualify because they were over income.
And if possible, can I say something about that?
Yeah, just a minute.
All right.
And last time we learned he was unemployed, she was at Adapt. She moved out and then moved back in February. And apparently Mr. Gilmore's gone back to work. What's the status, Mr. Gilmore?
Actually, no, I haven't gone back to work.
Are you
And
getting unemployment?
yeah,
Okay.
and the household being over the income limit, I feel like that's kind of unfair because the time that I'm asking for the help, she wasn't here at all. Like she literally hasn't been here since the last court date either.
Well, I'm not sure. You're both on the lease and you didn't qualify for help. If we add another $745 for June, 6460 plus 745 equals 7,205. That's how much rent is due through June.
Like I could have got the help, but to base it off of someone's income that wasn't in the household during none of this time, who still isn't.
Well, all right, so she's on the lease.
But she hadn't been
All
here.
right, so Heather, you're not there and you don't plan to return there?
She hadn't been there for the past.
Oh.
I've been there.
Ask her. Heather, what's your position?
I've been there, but I haven't stayed there because every time I go there, it's the domestic and the police get called, so I've stayed away.
That's not true, but okay.
But my stuff's still there.
She has nothing there.
The manager knows about it. I've called about it.
Even with that, how can she be allowed to stay on the same property as someone else's residence, but her income determines my living situation when her income was going to the residents on that property?
All right, well, let's take the free housing assistance, emergency housing assistance out of it. You've been living there for 10 months or so without paying any rent. That's not her fault. I guess she left. So the consequence of that is your landlord would ask for their property back. For reasons I don't completely understand, Keystone has determined that you're not eligible for any emergency help.
Because of Heather's income. That's the sole reasoning. Because of her income.
That's between you and Keystone, not between you and Memory Lanes. You're at Memory Lanes, you're living in their trailer, you're on their lot, and you're not paying any rent. They would rather you were eligible from Keystone so they could get their rent paid, but you're not.
And the reason you're not is because of solely Heather's income.
All right, well, that's apparently how they calculated it.
But how can that determine my status if the income that is being determined by has not been there?
Well, let me repeat, that's between you and Keystone.
No, this is not Keystone. This is not Keystone I'm talking about. I'm talking about the Michigan Syrup.
Yeah, that's Keystone. They're the housing advocate and they're our Michigan Syrup. I don't know the answer to that, but let's take them out of the equation. You owe $7,205 of rent through June, and your girlfriend's not staying there, or ex-girlfriend, so she's not going to pay any of the rent. but she's on the lease.
But she was the one that was doing the back and forth with Keystone. So she.
I don't know the answer. I'm just,
That's what I'm trying
I'm not telling you you're right or wrong. I'm just telling you that right now there's 7,000.
Because I had
$205 through June.
like I had the money. It's just the fact of
All right.
she's still gonna be involved.
Well, what you need to do, if she's gonna move, she needs to get off the lease and leave just you on it.
That was one of the discrepancies, because I was told, and I was given a piece of paper from the office saying that Heather pretty much relinquished her residency there. But then all
Christine,
of a sudden,
what can you tell us about that?
Your Honor, Heather left because there was some domestic violence.
no, that's not true.
And then she told me she came back.
Heather left because Heather chose.
Stop. It's her turn to talk. This is where their perspective is, so go ahead.
Heather did come and tell me that she was leaving because of domestic violence. She did tell me that she couldn't find a place to live, so she came back for a little bit. There was still some domestic violence, so she did tell me that she was out of the house at this time.
But she's still on the lease?
Yes, she is on the lease.
And I guess
When
one of
is
the,
lease up?
The lease is just ongoing, Your Honor,
So it's month to month.
month to month, ongoing.
well, and Heather, Your Honor, on April 12th, signed the EPD affidavit.
What is that for the emergency?
Eviction Protection Declaration
And
Oh,
affidavit.
when-
That was signed by Heather on April 12th.
That's when she had came back for those couple of days she was there. She didn't even want to sign that.
all right, so they've asked for a COVID stay. All right,
Like she
Um,
didn't even know that I felt those paperwork out, not her.
all right, well, here's the deal. You owe $7,205 in rent through June, plus 176.16.
I just don't understand this. I'm on
7,381.16.
nothing was.
That's how much is owed, and you have 10 days to pay it, which would be by June 17th, or you're subject to being evicted. And I will note there is a CDC stay in effect.
Actually, we would like to challenge that, because I don't think there's been any effort to make any timely payments on this.
All right, well, as a practical matter, they have to be given notice of that. You can challenge it, but by that time, it'll be June 30th.
And like I
Yeah.
said, this was all going off of what I was being told by the other party.
All right, well, so far, you've made zero effort, despite the fact you're getting supplemental unemployment benefits, to pay any rent. She was gone, she came back. Since you've been there by yourself, you've paid exactly zero. So Keystone, based on your unemployment benefits and other information and her information, denied your request for benefits, emergency housing funds. So you don't have any source of emergency housing funds, at least not from Keystone. But the rent is still due, plus court costs. So you have until June 17th to appeal this. As a practical matter, they can't probably pursue an eviction until June 30th. But as I said, if it was up to Keystone, up to Memory Lanes, they would just soon have the money to get the rent paid.
I understand that. I can pay that. It's just.
All right, well then if you pay it, then you're fine. What I would attempt to do is get a lease without Heather on it and just you on it. But if you pay $7,381 by June 17th, then your tenancy continues. If you don't, you're subject to me being evicted on or after June 30th when they lift the stay, unless they issue another one. And we have no way of predicting that. Heather, you don't have a preference one way or the other. Heather, would you like an opportunity to get your stuff out of there?
She has nothing. in.
The problem is that the 7 years or whatever that we lived there, I was the one with the job and paid all the bills. So I don't know.
All right, well then, if you're not really care, I guess,
Payments
you're
on
out.
if we could get him off of the lease, I would make payments on the actual.
All right,
amount,
so if you
but I'm
got
not gonna
him
pay
off the
for
lease, you would come back.
And that right
But
there,
right now,
Yeah.
you're both on the lease.
and that's the whole thing.
All right,
If I'm the lease, if I'm there and she's not, how come everything is going through Heather? I knew
all right,
nothing,
let's just,
I knew nothing about the Keystone.
because
thing.
you're both on the lease.
I knew
She
nothing.
wasn't-
I was the last person. The last time I talked to the leasing lady was in June when I paid the rent.
June of last year, no, she disagrees. All right, well, here's the bottom line, Mr. Gilmore. You gotta pay $7,381 within 10 days or you're subject to being evicted. And there's a CDC stay till June 30th from the Center for Disease Control. And you filed for the claim. In fact, Heather helped do that. So I'm gonna remove you from the queue.
About that.
Your Honor, is he covered under that if she filed it and she doesn't want to be there?
Probably. If you do pursue the writ, we can have a hearing on it, also the good faith effort. He says he has the money. I tend to take that with a grain of salt. Heather, you're free to go.
Thank you.
All right, we have another no-show, it appears. We have Steve, I'm not sure who this is.
Do you have the judgments there, Your Honor? I mean, we sent them before.
I do, yes, thank you, John.
Okay.
The next one is Memory Lane Mobile Home Park versus Donald Rhodes and Nicole Roy. That was actually our 120 case. We had our previous hearing on April 30th, and they were going to apply for benefits. They aren't here. Bettina, what can you tell us about that?
They have applied and they currently are approved. They've been approved for the amount of $7,521, and the checks will be released sometime this week.
All right, well, that's good news. Our finding last time was that the arrearage was 5,436, so that probably pays the rent at least through June. John, we can do a couple things. We can adjourn this 7 more days to wait for the check, or issue some sort of a writ here today, but it appears the rent's going to be paid.
I wouldn't object to just adjourning and wait for the check. Then we could.
All right. Let's continue 1 more week to June 14th.
Can I check that date real quick? What time are you asking?
Yes, I would do it at 1:15.
At
I don't know if you got cases on there already.
In the
Let's take a-
afternoon?
Yes, that's a Monday. Let's see if you're set to be here anyway.
Your Honor, I got a 2 o'clock juvenile. We can work around it on the 14th. We can.
All right, well, if they pay it, it'll be a real short hearing. Let's go with 1:15.
All right.
And hopefully that we won't need to take any court time. All right, anything further we need to do on memory lane?
I'm good. Thank you, Chris.
Thank you, Your Honor.
Okay, thank you, and thank you, Bettina.
You're welcome.
Thank you.
You're welcome.
All right, $7,521 is nothing to sneeze at. All right, and our earlier memory lanes person, Tristan Angus, has not showed up. I will show that as a default with the date for the writ of June 17th. That's file number 21428LT. All right, that's our first three cases. 115. That brings us to our 130 case. It's now 135, so we're 5 minutes behind. And that would be JRD Companies versus Berg. Mr. Lance Thornton is here on behalf of JRD Companies. Karen Berg is not present. This is our second hearing. They had no contact from the defendant. Josie, the manager, is here. And Bettina, have you heard from these people?
Yes, Your Honor.
Okay.
Their application is currently in the processing. Still trying to finalize some documents and some information.
Well, they aren't here. That's not helpful. Lance, what can you tell us?
My understanding was the same, that Ms. Berg has started to work with Keystone, but I checked with Josie this morning, and we have not received a signed CDC declaration still at this point. So my request would be to move forward with the judgment. I guess if we get the check, we get the check. So.
Well, let's figure out how much is owed here.
I should
At
have
that
sent,
time,
I sent you a new judgment info sheet this morning, Judge.
here it is, thank you. $1,064. You got some late fees, 50, 50, 50, 10, 20, 30, 40, 50.
Your Honor,
Yes?
I just wanted to say Karen Berg did just text me and said that she lost her court paperwork to get into the Zoom meeting, so I just sent it to her.
All right. Good afternoon, Mr. Black, Mr. Green, and Mr. Steve Brown. Are you here on the discovery hearing, Mr. Brown?
Bank versus Lynn Friend at 145.
For Escamilla? Oh, no, we've got a couple other things. Yeah, you're right. We've got a couple motions. All right.
What I just wanted to let you know on that TD Bank versus Friend, there has been an agreement that's been reached as to a payoff, which has been done. Buckles and Buckles' office advised me last week that they had sent a dismissal to the defendant's debt consolidation company, and they had not got it back. And they wanted me to ask you to adjourn it. And I'm just here in case you had any questions for me.
All right, well, stick around. We'll deal with that in a minute. I think we may have Karen Berg here.
Yes, you do.
Miss Berg, can you hear me?
Yes, I can.
All right, apparently you lost your stuff.
Yes. Oh, Lord.
All right, let's start over again. This is JRD Companies versus Karen Berg and any other occupants for a property at Cato Lane. As of today, rent is $1,521. $14 in arrears, plus a service, or plus process serving fee, filing fee, and attorney fees. Lance, the law doesn't allow $75 for the second hearing yet. They should, but there hasn't been a provision for it, to my knowledge.
I wasn't sure on that. I included it.
Well, it certainly would make sense, but 55 plus 75 plus 5288. 18288 plus 1014 equals 1,196.88 through June. All right, Miss Berg, your rent through June is $1,014 in arrears. The court costs, service fee and attorney fee are $182.88. 1014. 182.88. That adds up to 1,196.88 through June. Bettina from Keystone tells us that you've been there to see them and started the process application for emergency housing funds.
Yeah.
I don't have any reason to think that you won't be eligible, but when did you contact them? We adjourned this 37 days ago.
I probably contacted them 21 days ago.
All right, well, I guess this was May 7th. We adjourned this exactly 31 days ago. Mr. Thornton is here on behalf of the complex, and what he's asking for is we simply get the judgment, and before I do any writ of eviction, I would wait and see whether there's availability of emergency housing funds. I'll put defendant has applied at Keystone. The best case scenario is Keystone pays your rent maybe through June or even July, and then you get to stay there and the case gets dismissed. The worst case scenario is they determine you're not eligible. I would have a further hearing before I signed a writ of eviction. But according to this, you would have until June 17th to move or be subject to eviction. Your manager, Josie, is here. I recommend that you stay in contact with her. And Bettina, if they some urgency behind this application, that would be very helpful. All right, Ms. Berg, you do also have 10 days to appeal this. My hope is that Keystone will pay this and you will be good for a while longer.
Absolutely, mine too.
Are you employed?
No, but I'm looking for work right now.
All right, because yeah, this won't last forever. If they do pay it, it'll only
Sure,
be through
right.
June or maybe July, and then we're going to be right back in it. All right,
Yeah.
$1,014 through June plus $182.88. The date for the writ and the appeal is June 17th, and I'm hopeful it will be paid. I'll confirm that before I sign any writ of eviction. All right, you're free to go. All right, now I have a phone number here. Lance, anything further we need to do on that?
Nope.
All right, let's see who this number is. Who's 269-221? Here's O'Donnell. Take clan out of it. Rename. All right, the O'Donnells are here. Is Mr. Giosa, is that you, sir? 269-221-2222.
That's me, Lynn Friend.
All right, Ms. Friend, stay right where you are.
Yes, sir.
Mr. Joseph does not appear to be here. This matter is set for 2 p.m. and it's only 1:45, so we can't do anything on that. So let's address Ms. Friend.
Your Honor, I'm going to sign off. I don't think I've got anything else with you.
All right, thank you, Lance. I'll let you go. I'm sorry, I forgot you were in there.
That's all right.
All right, Mr. Steve Brown is here. In this matter, which is called TD Bank USA versus Lynn Friend. File number is 21257GC. It is a claim for $1,356.14. It is a Buckles and Buckles case. Mr. Brown appears on their behalf from time to time as limited appearance counsel. Mr. Brown, could you put your appearance on the record?
I'm attorney Stephen Brown. My bar number is 24389, and I'm appearing for the purposes of today's hearing only on this matter.
Ms. Friend, Mr. Brown, it gave me a little background before you logged in. Apparently, Mr. Brown, there's an effort to resolve this with a payment in a debt consolidation company.
Yes, sir.
Mr. Brown, what can you tell us about that?
Tenant has paid the money, as I understand it, and a dismissal has been sent to her power of attorney debt consolidation company a couple of weeks ago, and they have not received it back yet. So we've asked you to adjourn it, or in anticipation that they will send it back, and that a dismissal will be forwarded to your honor for entry.
Ms. Friend, is that your understanding?
Yes, sir.
All right. This isn't a case of the checks in the mail, it's a case of the dismissal order is in the mail. So I'm going to adjourn this 21 days. Today is June 7th. I will continue at request of both parties. To await receipt of the dismissal. To June 28th. At 1:45. If the dismissal order comes in, nobody needs to appear. All right, Ms. Friend, are you still at the Indian Prairie Road address?
Yes, sir.
All right. If you have any influence with your debt consolidation company, you can light a fire under them to send that order of dismissal back, and the matter will be resolved. But apparently, you've worked out some consolidation and paid a lump sum. Do you have any questions?
Sir. No, I called the Beyond Finance Friday and asked them if I still needed to do this hearing because the settlement had been made and was paid on May 14th. So I will call them again and tell them I need that order of dismissal.
All right, very good. Hopefully it'll come through and the matter will be resolved.
Your Honor, I have a question.
Yes.
Your Honor?
Yes.
Quick question. Is it easier for your office to, sort of manage this and oversee this, to have schedule it for a hearing, or just schedule it for like a status review?
Well, I schedule it for a hearing, which will be a further hearing regarding the motion. So the 21 days will tickle it. We won't let it languish. And If the order is received, great, we'll dismiss it. If it isn't, everybody will have a notice for June 28th at 1:45.
Thank you very much, Your Honor. Have a wonderful
Thank
day.
you, Mr. Brown. You're good to go. I'll see you next time.
Goodbye.
All right, move Mr. Brown, and Ms. Friend, I'll remove you as well.
Okay, thank you, sir.
All right, we have a couple other civil matters. Then we will have some small claims. Ms. Salisbury, are you there?
Yes, Your Honor.
Click, and all of a sudden there you appear. This is set for 145, it is 150.
Your
So
Honor,
Yes?
for the clerk wanted me to put on the record, I was actually just requesting an adjournment, so hopefully I can make this real quick for you. Mr.
All right, well, let me call it first, so we're all in the same frame of mind here. This is Omni Community Credit Union versus Craig Monday. File number is 201569GC. Ms. Stacy Salisbury is here on behalf of her partner and law firm mate, Lon Escamilla. This is a discovery hearing, I believe, and it's ordered to show cause for failing to appear. What's the status here?
Yes, thank you, Your Honor. Mr. Monday has apparently moved from his prior address, which he was served with the discovery subpoena. Our process server has indicated they have a new address for him. He needs to be personally served for this show cause hearing, so we've asked the clerk to provide us with a new date for hearing.
How much time do you need?
30 days would be good.
All right, let's see who this is. Well, I had LG Style 03, but I lost them. That might be Mr. Giosa. All right, today is June 7th. Summer's fleeting. We'll be busy on July 5th. I'm on vacation on July 12th. Well, we have to go. I could set it for July 9th at 10:30. Oh, wait a minute, that won't work. No, that'll work. That's a Friday. Otherwise, we have to go to July 26th.
At what time, Your Honor?
Well, July 9th would be in the morning, 10:30.
Okay.
All right.
That works for me. I appreciate that, Your Honor.
To achieve personal service. I was looking at what notice he has. Motion order to show cause was he was personally served for the default. All right, well, I'm certainly willing to allow you to attempt personal service, and we'll continue this to July 9th at 10:30. That's a Friday morning, right before my vacation starts.
Thank you, Your Honor.
All right, thank you. I'll see you again. Thank you. That's the civil pile. All right, we have several increasingly difficult cases left. The O'Donnells and Jim Giosa are set at 2. Mr. and Mrs. O'Donnell, I'm just going to let the clock tick for 5 minutes and turn the record on and see what our status is. Bettina, this is a termination, and the next two, Learn and Howard, is a motion to set aside a default, and Salado versus Holman, I guess I might need you on that. It was a non-payment of rent, she didn't pay the rent.
Would you like me to hang out until then?
Yeah, or click back in at, what time is that set for? At 2:20.
Okay, will do.
All right, thank you.
You're welcome.
Three more minutes. Two more minutes. Here's somebody. Good afternoon. Who am I speaking with?
Hi, this is Jim.
All right, thank you. I'll get you a name here. Mr. and Mrs. O'Donnell, why don't you unmute your mic there? This is file 21708LT. It's entitled Sean and Christine O'Donnell versus Jim Giosa. This is a termination of tenancy matter. We had a hearing on May 24th. I wrote the 25th, but it was the 24th. And we continued the matter until today. It is a termination of tenancy. There is a lease that expired in February, and the O'Donnells are asking for the premises back. Mr. Joseph, when we talked last time, I wasn't clear what the status was, whether you were going to try to vacate or what you are now. Are you still there?
Yes, we are, and my intentions are the same as I had shared last time. It's their property. They've been great landlords. I'm more than happy to leave the property and pay them for any time here in June, because I've already been paid through the month of May. So any time that we had used in June, I'll pay, and I'll be literally out, I would hope, by the end of the month. But if you give me instructions otherwise, I'll do that too. So you had said prior in last meeting
I have a question. The lease also contains a Kathleen Basha. She's a signature to the lease. The termination of tenancy is only as to Jim Giosa, I guess, and all other occupants. I guess that would include her. So is that your intention, Mrs. O'Donnell, to get your property back from Mr. Giosa and from Ms. Basha?
Yes, please, Your Honor.
All right, somehow the notices just came out in his name only, but her name wasn't placed on there, but you did include all other occupants. Mr. Giosa, is Kathleen Basha still there with you?
No, she's not.
Okay. Well, the law says you have 10 days from today to move. I find by hearing that you have until June 17th to move, or you're subject to being evicted. Now, they can agree to let you stay longer. That's up to them. They don't have to evict you on June 17th. They have 56 days from today to ask for the writ.
No, sir. There's no need to put them through anything more than I already have, and I'll comply. I would appreciate the end of the month if that's possible, and I will pay for the month.
All right. Well, that's between you and them. But I didn't pluck this number out of a hat. The law says 10 days from the hearing.
What can I respond?
If they wish to allow you to stay to the end of June, that's up to them. Let me repeat that, Mr. and Mrs. O'Donnell. When I order an eviction date of 10 days from today, the date of the eviction, the earliest it could be would be June 17th. The latest it could be would be 56 days from today. So you don't have to evict them on June 17th. You have 56 more days to actually ask for the writ, and then actually another 56 days before you serve it. Otherwise, you'd have to start over again. But I'm not ordering any money paid at this point. This is not a money judgment, it's a possession judgment. If there is going to be a lawsuit over money, it can either be in small claims court, I guess. There's a dispute about the bounced check for the security deposit. If June's rent is paid and there's no further damages to the property, May's rent is paid. If there's a money issue, it can be brought up in a separate proceeding. This is called a possession judgment. You have till June 17th to move, or you're subject to being evicted unless your landlord gives you additional time. Mr. and Mrs. O'Donnell, do you have any questions?
No.
Mr. Giosa?
No, sir.
All right, hopefully you guys can communicate with each other and make a smooth transition here. If not, if there's need of further hearing, either party can petition for it. All right, you're free to go, Mr. Giosa. June 17th. We'll send you a copy of this order in the mail. Mr. and Mrs. O'Donnell, you're good to go as well.
Okay. Thanks, Your Honor.
Thank you,
Appreciate
Your
it.
Honor.
All right, now we have two other matters which are a bit more contentious. Good afternoon, Mr. Davidson.
Good afternoon, Your Honor.
We gotta let the clock tick a little bit. This one is set for 2:20. I got your pleading.
He has not seen that yet. So in fairness to her, I wanted to let you know that I had it done, I believe it was late Friday, and Cheryl took the afternoon off. And so point was I didn't get it out to you this morning, but the defendant, I didn't have an opportunity to mail it to her. So she hasn't seen it, that's all.
All right.
It was just argument anyway, but in fairness to her, she has not seen it. Your legs sore from riding bikes?
I rode my bike this morning at about 5:50, but I didn't ride it at all on my trip. So
I had two high school buddies that called me on Friday and said they were coming over for the weekend. So that was...
Well, good. That was probably a good weekend to do it.
Oh yeah,
All right,
we laughed a lot, mostly at ourselves.
That's good medicine.
Well, as long as I checked in, I'll be back in a second.
All right, here's Miss Learn. All right, good afternoon, Mr. Learn. Mr. Davidson is here. We're waiting for the defendant to appear. I'll put you in the waiting room. You're in the right spot. Can you hear me?
Very clear, sir.
All right, very good. I think we got our logistical problems cleared up. Good mic, good picture, we're all good. I'll see you in a minute. Okay. 210.
Hey there, handsome.
Oh, you must be talking to Mr. Davidson. Here is LG Style 03. Let's see who this is. Uh, Says they're still joining. Lost them.
Can Matt hear me?
He's on mute.
You're dang right I can. Be careful.
Okay, we're on a live stream and we are recording. And we're on Zoom. And so we're waiting for LG Stylo. And it seems like they flashed on my screen earlier.
Had something fun happen yesterday.
Yeah.
All right.
On.
All right,
Couldn't
well-
have been more than a day old. Came up
Oh.
and outside our window and was drinking from the river. It was the first time I'd ever seen anything that cool.
That's cool, isn't
Well,
it?
let's call the case. I don't know who LG Stylo is. We'll see whether they return. This is Monroe and Vicky Learn versus Jennifer Howard. It was filed as a termination of tenancy. The notice to quit was served way back in March. I was aware that there was also a personal protection order matter in effect. Mr. Davidson wanted to make sure that me, as the landlord tenant judge, knew there was a personal protection order. And he wanted Judge Pattison, who was the personal protection order judge, to be aware that there was a landlord tenant case. So Judge Pattison and I did discuss it. I watched as much of the PPO hearing as I could in light of other things I had going on, but I watched enough of it to know that Judge Pattison terminated the personal protection order against Mr. Learn. This is filed as a termination of tenancy. I learned through that and other discussions there was a fire on this property, and that was part of the issue. Now let's see who this is. Mr. Salado will be with you in a minute. We're going to take care of this other matter.
Okay.
Lost her again. Ms. Howard, can you hear me? I can't hear you. Ms. Howard, can you hear me?
Turn audio on.
Now I've lost Mr. Davidson.
He's still on our screen.
He's not on mine. You can see him?
Yes.
Well, that's odd.
Modern technology.
Ms. Howard, can you hear me? Matt, can you hear me? These are exercises in controlling my frustration. We lost her again. And I can't see Matt. I think he's lost.
Somewhere. He's here on our screen. We transported him. He can't hear me though.
Matt is now coming back. He was gonna take care of something else, but let's try to bring her in again. Welcome back, Matthew. He changed locations.
Sorry, Your Honor. My microphone couldn't be seen anymore, and it was too complicated to fix, so I'm sorry.
All right, we're still trying to get the defendant logged in without much success. Mr. Salado's client is just logging in also. Ms. Holman, can you hear me?
Yes, Your Honor, I can.
All right, I'm going to put you in the waiting room, okay?
Okay. I was trying to get on here. I was trying to get Zoom, but I have such problems picking up my.
Well, it's. Yeah, people experiment 1 minute before the hearing starts.
I've been trying, Your Honor. I'm trying. I've been sending pictures. If you can see, I have everything laid out. I got a chalkboard and everything. I'm like.
All right. Right now, I'm going to put you in the waiting room. All right. Now, Ms. Howard, can you unmute your microphone?
Yes, can you hear me now?
Hear me?
I can hear you.
All right, these hearings are scheduled on very tight notice, and we've just squandered 10 minutes waiting for you to get logged in. This is a continuation of a hearing in Monroe and Vicky Learn versus Jennifer Lynn Howard.
Yes,
And Jesus Borrego Villarreal.
That's
Was he
correct.
also there?
Yes, he is here. He's right here.
All right, okay. Now, this was filed as a termination of tenancy. The notice was served back in March. The Learns want you to move from this property on Lang Road. We had a hearing on May 17th and you did not appear. So at Mr. Davidson's request, I issued a writ with a 10-day order. You then, on the 25th of May, which was within 10 days, filed a motion to set aside the default on the official form. And your reason is, I did set up the Zoom app and it was all ready to go for Judge Middleton to have me join the call, but due to technology problems, it went against me and kicked me out. We just struggle with that here again today. Mr. Learn, at this point, still wants you to move out of the property. What's your position?
Oh, we want to move. We're tired of being like the harassment. But all we've been asking for is time. I'm with one arm. My husband is hurt. I have a baby and then 2 almost teenagers. So it's kind of it's hard and we can't just move anywhere.
I hear this every week, twice a week. People would move if they had somewhere to move to. Bring Miss Holman back in. The fact remains, they want you to move, and I don't believe any rent has been paid since, I don't even know when the rent was last paid. Mr. Learn, when was the last time any rent was paid?
2019.
Well, at some point they worked for you, but when did their employment end?
Almost a year ago.
Mr. and Mrs. Learn have wanted you to move for a year, and you haven't moved, and now they filed a notice to quit in March. It's now June, and 3 more months have passed. And what happens is people don't move because they can't find anywhere to move to. So this could go on for 5 years. And that's where this hearing is about. It just gives a drop dead date, and if people don't move, the sheriff comes, puts their stuff out on the street. Now, Mr. Davidson has filed an objection to your motion, but you haven't been served a copy of it. So I don't really want to consider it without you having had an opportunity to view it.
That's all right, Your Honor. Don't worry about it. I'll make a verbal presentation.
All right. Mr. Davidson, you object to her motion to set aside the default?
Yeah, I do, Your Honor. The actual date for her to move under the order, and just at least my recollection of the procedure is that the court entered an order of possession, and then with the 10-day period, that period ended on the 27th. Out of deference to the fact that we were having this hearing today, I did not present a writ to you on the 27th. I would have otherwise. And but it's my position that when somebody files a motion to set aside a default judgment, they need to plead and present several different items, one of which is that they have a defense. If she had been here and participated, there really isn't, I mean, nothing that she's brought up now is any different than what she would have said on that day. So by virtue of filing this motion, she's received an extra, 3 or 4 days at the end of last month, plus another 7. So she's got—
Well, the 27th, 4 plus 7, 11 additional days.
Got 11 additional days, and we simply ask that the court deny her motion, and because she hasn't met the procedural requirements to set aside a judgment, and we'll submit a application for a writ. But I mean, I could go through the court rules.
No, that's fine. I'm familiar. She's probably not.
But her absence was harmless because the judgment would have entered even if she'd been present, at least based on everything she said now. And she failed to state a valid defense to the complaint or grounds for relief from the hearing, all of which are required to set aside a judgment. So it's simply too little too late, Your Honor.
Ms. Howard, they're saying essentially you don't have any defense. They want you to move, you don't want to move. You failed to appear for the hearing because of technical problems, but you haven't stated a meritorious defense. Your defense is we can't find any place to move to, and that's not a defense. So what Mr. Davidson is saying, if you had showed up at the hearing, I would have given you an order to move by May 27th. You didn't show up at the hearing, you asked to set it aside, and I set the hearing for today, which gives an additional 11 days, and they want their writ now.
They want their what? I'm sorry?
They want you to move. They want the sheriff to come put you and your stuff out in the street. A writ of eviction. So you filed a waive the fee on the motion to set aside the default. You didn't show up because of technical problems, but you don't have a valid defense. You haven't stated a meritorious defense to the writ of eviction. You have no lease. You're no longer working for them. You've been there more than a year since your employment terminated. You filed a personal protection order against them, which Judge Pattison dismissed, and he wants you to move. So Mr. Davidson is going to submit for a writ of eviction, and within the next day or two, the sheriff's going to come put you out on the street. Mr. Davidson, is there any grace, or you're simply going to ask for an immediate writ?
Your Honor, there's other extenuating circumstances that have to do with her having sales of the plaintiff's property and so on and so forth. I really don't want to get into all that, but there are important reasons for us to move on this issue that are, again, just to let you know, they're exigent circumstances. Things have not been quiet simply because we haven't been in court about it.
All right, the motion to set aside default is denied. You may submit an order denying the motion to set aside the default and ask for a writ.
Thank you, Your Honor.
Which means within the next day or two, the sheriff is going to come out with a writ of eviction to put you out of the property.
Your Honor.
Yes.
I have not even spoken anything about the eviction, so I don't know what he is going by. We have not even been unemployed with him for a year. It's been just recently. I have the messages here. We never got an eviction from them a year ago. This is the first of ever an eviction.
Well, you got one now. They served the notice to quit on you in March. It's now June. And in your motion to set aside the default, you failed to state a meritorious defense. And even here, you just said we haven't got anywhere to move to. They want you to move. They want you to move immediately. So you have no lease.
I have a lease here. I have a lease here, Your Honor. I have a lease here.
All right, but it's expired.
And I have also an audio recording of why he wanted to evict us was because I talked to the cops about a fire. That's the only reason why he wanted to evict us.
Well, I don't know if it's the only reason, but he followed the appropriate steps. You may have had a lease some time ago, but you're no longer employed there. You're not paying any rent, and he wants you to move. And there was a fire there. I'm not even sure how habitable the premises are. So Mr. Davidson is going to submit an order denying the motion to set aside the default and for the writ. That's an unpleasant, harsh reality. So you should proceed accordingly and start to get your stuff out of there before the sheriff comes. All right. I'll remove these parties.
Thank you, Your Honor.
All right, Mr. Martin, thank you.
Thank you, sir.
Mr. Davidson. All right, now this next one is kind of also in the same unpleasant vein.
Your Honor.
Yes? Yes?
With it being in retaliation, that's why I'm getting evicted. It's because of retaliation. We would pay rent, and then we had an agreement because we just recently just stopped just because he was even working with him just a couple weeks ago.
Can you hear me, sir? Can you hear me?
Yes.
My name is.
All right.
Can you see me?
I can hear you and see you. I made an order that you have failed to state a meritorious defense in your claim for a termination of tenancy. And I denied your motion to set aside the default. You don't have to like it. That's my order. You have 10 days to file an immediate appeal. But I'm not going to sit here and debate it with you because I made a ruling and you, they want their property back and you would move, but you can't find a place to move to. So I'm going to remove you once again. All right. All right, so the other party wasn't here. We may hear more about that, but they certainly didn't plead well. Oh, here's the motion to set aside the default. All right, the next matter is Ken Salado versus Darlene Holman. This is an application for a writ of eviction. We had previous hearing in this matter. Ms. Holman, can you hear me?
Your Honor, I can.
Let's see who LG Style 6 is. Good afternoon. What case are you here for?
Who are you talking to?
LG Stylo 6.
I don't know.
What case are you here for? Well, they're not here for this one. All right. This is file 21415 LT. It is a motion to terminate tenancy. I did an escrow order that Darlene Holman, it's a demand for non-payment of rent. The Darlene Holman was to pay $1,200 per month. Our first hearing was on April 9th. I made a finding that the rent through April was $3,110. Defendant had made no contact with Keystone. She had a number of complaints about the property. So on April 9th, I did an escrow order that she was to pay to the court April's rent due by May 1st. We had a second hearing on May 10th, and Mr. Salado was here, Bettina from Keystone was here, and Ms. Holman was here. She had not contacted Keystone for any rental assistance, and she had not paid any money into the escrow account.
Your Honor.
In the yes?
Ms. Holman was not at the May 10th.
Oh, defendant failed to appear. That's correct. She wasn't here at the May 10th hearing. Then Mr. Salado applied for a writ of eviction, and I was prepared to sign it, and Ms. Holman filed a bunch of stuff, which is very difficult to discern, but she never actually filed a motion to set aside the default. So you weren't here on May 10th. You didn't pay the money into escrow. You didn't ask Keystone for housing assistance, and you have not properly filed a motion to set aside the default.
Your Honor, I didn't put the money in escrow because when we spoke at the first hearing, I asked you if you would send me paperwork as to what to do, and you said you would, and I never received anything.
Yeah, we sent it to you at 68935 Winding River Road.
That's not my, Your Honor.
What?
That's not my address.
Well, let's see where we sent it to. Six 6935 Winding River Road.
66 is 2 6s. Either way, I never received anything. I have my, I do have proof of my bank statement that I have.
I can't hear you, ma'am, so just a minute. All right. Defendant has filed no motion to set aside the default. The default judgment entered on May 10th. What defendant did file, I have a hard time even figuring out what it is. Filed on May 24th.
That's one of many.
Yeah, but it's not within 10 days of the writ.
Yeah, I did email on the 10th day, Your Honor. Like 4 emails that day.
Well, you haven't filed a motion to set aside the default. You haven't paid any of the escrow amount. You didn't file for the writ or pay the fee or get a waiver. For the motion to set aside the default.
Waiver.
All we've got is this bunch of really hard to read, very small print, lengthy stuff that I can't frankly even make head nor tail out of. Mr. Salado wants you to move I told you how much the rent was, and I directed you to contact Keystone. You didn't contact Keystone, you didn't pay the rent, and you didn't put the money into escrow. And then you didn't show up for the hearing, and you haven't stated a good reason for not appearing for the hearing. So, what else do you want to tell me?
I've done everything through emails. I've tried to communicate the best I can. I've sent, I don't know how many emails to a couple, the lady and the
Well, did you send any of those emails to Mr. Salado?
Yes, I sent him copies of them today. Yes, I did.
All right. Have you made any effort to move? You're telling me how deplorable this property is.
Yes, I have. I have whatever proof you need. I have it all. I have talked with Keystone. I have talked with, I got a list of people I've talked to. I've talked to the YYYY Housing. I got a list of private landlords. I got a list of rental places that take Section 8. I've made contacts. I've been filling out forms. I've been doing a lot to move, Your Honor. I kind of like waiting to see what's happening today with this case, you know.
Well, I can barely hear you. Bettina, did Keystone have any contact with this person?
Your Honor,
Yeah.
I cannot say that. I don't have any knowledge on
But she did contact for emergency housing assistance?
Oh, that's another department, so she potentially may have.
But your department paying the rent, no contact, but she may have contacted another emergency housing division.
Yes.
Ms. Holman, what do you want?
Well, I mean, for one, you know, I'm going to need more time to move. I'm like trying. First of all, there's a lot of arguments with what's being the amount that is said that I owe. I have proof of something different. There's been, you know, of course, I felt that he did this in retaliation because of I told him that I was filing a civil suit against him. The next thing I knew, he did it.
I can't hear you.
No.
You said you were filing what?
I emailed him. I think I sent you a copy of it, that I was going to file a civil suit with him at one point when he was threatening to put me out or file eviction or whatever. And
frankly, Ms. Holman, I couldn't even read your pleadings.
Well,
I need a microscope the print was so small. For one thing, it wasn't a motion. It was just a bunch of random emails which went on with very hard to follow. And then Mr. Salado had said, I'm submitting this order to put you out. And so you didn't file a motion to set aside the default. Whatever you did file was more than 10 days after the default entered. You didn't pay the money into escrow, and you haven't stated a good reason for why you didn't show up on May 10th. And you never contacted Keystone from any emergency housing funds. So when he told you were going to serve the writ of eviction, you filed this stuff, which frankly, I just can't even read it.
Well, I apologize, Your Honor. You know, there's like not being able to have contact and get the proper paperwork and evidence to you, you know, is a burden on my part. You know, I'm doing the best of my ability to submit what I need to submit in my defense.
Well, and I'm trying to be helpful, but you're not doing a very good job of it. Mr. Salado is entitled to have you follow the rules. He's following the rules.
No, he has no rules.
Well, he filed the writ of eviction. He paid. He went through all the steps. You don't show up for the hearing. You don't pay any of the escrow that I ordered, And then you file a bunch of stuff 14 days after when he asked for the writ of eviction. You also haven't filed for she filed for a CDC stay?
Yes,
You did?
I have all these emails. Yes, they've been going to mostly the clerk, I believe, is who I've been sending most of my information to. I'm not getting no response. In one of the emails, I said, I'm not sure if I'm doing this properly. And I never got no response, so I just kept sending them.
I do not see a request for a writ of eviction stay. You could still file one, which would prohibit your being evicted until June 30th. All right. I'm going to do an order here. No, we just lost her. What's she talking about when she says this isn't her address? We sent the documents to 66935 Winding River Road. Is that an incorrect?
I think that you just misspoke the first time. I think you said 68935.
66935. Well, let me look at the
It is
escrow.
correct address is 66935, but I think the first time you said it, you said 68935, and that's what she was ready to say. That wasn't her address.
Let me look at the escrow order. Is 66935. Yes, it went to that address.
That address.
As ordered. Ms. Holman, can you hear me?
Yes, Your Honor.
All right. Any future hearings, if we ever had one, you may just have to come into the courthouse where we can put you in the conference room. I'm doing an order.
That would be great.
That denies your request to stay eviction. It wasn't really an order. It was a request. You didn't make a motion. You just sent a bunch of stuff. And that's not your fault, you're not an attorney, but I advise you of the right to
No,
contact our other attorney.
I've been contacting them, Your Honor. They
I will,
basically told me I couldn't afford them, and they usually represent the landlords, not the tenants. I have spoke with 3 of them.
well, that's not legal aid. You may have talked to private attorneys that represent landlords. All right, defendant did not file a motion to set aside the default. No good cause shown as to why she did not appear on 5/10/21. Anything she did file, not within 10 days of the order. She did not pay the escrow as ordered, which was sent to her at 66935 Winding River Road. So
I never received no order.
well, we sent it to that address.
Well,
The
it
escrow.
sure didn't
And I
come
told
here.
you on the record that you had to pay it by May 1st. You didn't pay April's, May's, or June's rent.
Are you going to send me the paperwork to do it?
Stop. When we have lawyers in here, they don't just shout over me and talk over the top of what I'm trying to say. Mr. Solaro's not doing that. So I'll give you a chance to speak, but it's very impolite and unprofessional to interrupt the judge when he's trying to explain things to you because you don't like what I'm telling you. Anyway, you didn't do it right. You didn't show up for the hearing. You didn't show good cause as to why you didn't show up for the hearing. You never filed a motion. You never paid the escrow, and you're still there, and he wants you to move. Now, the other thing you have not done is you have not filed a CDC declaration. If you immediately file one of those, he won't be able to evict you until June 30th. The writ of eviction will remain stayed for 2 days for 48 hours to the end of, to 5 p.m. Wednesday, June 9. To allow a defendant time to file a CDC request for stay. When you make an argument that the property was insufficient or inhabitable or there was a retaliatory eviction or those things, I ordered that you actually pay the rent before we argue about those things. In the meantime, you've stayed there for April, May, and now June. Mr. Salado is not getting any rent. You're still there. You haven't moved. Now, the CDC stay could allow you to stay there until June 30th. But in order to hear all these things you wanted to tell me, I ordered that you paid the escrow amount, meaning you pay the rent, and I hold on to it. But you didn't do that. So you've got 48 hours by Wednesday at 5 o'clock to file for a writ of the CDC stay, or you may be evicted on Thursday. June 10th. All right, now I'll give you a chance to speak. Anything else you want to tell me?
No, I'm going to make sure you get my evidence properly. I'm not going to send it through email no more.
Well, that's one thing. The problem is you didn't pay the escrow. You have to pay the rent in order to bring all these things up. You're alleging this and this and this and this, and you're not paying the rent. I offered you to go to Keystone to get some emergency financial help, and you didn't. And if the place is as bad as you say it is, you should get out anyway. And then the problem is you can't find a place to go. But Mr. Salardo's frustrated. He's asked for the writ of eviction. You filed a bunch of mumbo jumbo. You didn't pay the fee. You didn't pay a motion to set aside the default. You didn't show good cause. And you didn't pay the escrow. So, that's not how it works. You don't just email the court with a bunch of stuff and hope that it sticks. All right, let me repeat. You got 48 hours till Wednesday at 5 o'clock, June 9th to file for a CDC stay, or Thursday you're subject to being evicted. I've done an order to that effect, which I will send to you. All right, you're good to go. Thank you. Mr. Salado,
Thank you.
we'll just do the best we can do here.
I know, I understand.
All right.
It's hard, and on the CDC, she has to meet all those requirements, correct?
Yes, she does.
5 items, I believe.
All right, thank you. All right, Bettina. Thank you for your help as always.
Yes, thank you, Your Honor.
Okay, I'm gonna stop the record here. And I'll start